who was an individual who was interviewed by law enforcement in Bristol on the night of June 25th and into the early morning of June 26th, culminating in a polygraph examination that was administered. I think it started shortly before midnight and concluded sometime after midnight, the 25th into the 26th. Mr. Ortiz failed that polygraph test. That is, the polygraph examiner determined that he had been deceptive. And later that day, on June 26th, I don't think we have the precise time of day from the papers, but later that day, an application for the search warrant was filed in Bristol, relying on what Mr. Ortiz had told law enforcement, omitting what we say, deliberately omitting what we say is the rather critical fact that he had flunked the polygraph exam, and therefore that whatever he said should not be deemed reliable information upon which a magistrate could justifiably make the finding of probable cause. So that, and so our argument is that this deliberate omission of material information from the warrant affidavit under Franks and its progeny renders that warrant fatally flawed, and it should not have been issued. And what we've asked the court to do under that line of cases is not to invalidate the subsequent warrants at this point, but rather to hold an evidentiary hearing as to whether or not, in fact, a violation has occurred, and a violation has occurred which would justify the remedy we seek.
In the evidentiary hearing to determine what?
To determine whether, well, in its papers, the Commonwealth suggests that maybe the affiant in Bristol didn't even know that Ortiz had failed the polygraph exam. So if it wasn't,
hadn't been given or
whatever. I mean, if it wasn't
read by that point,
right. If it wasn't deliberately omitted, then we don't have an argument, obviously. So I think that's the first argument. That's really that would be the key, I think, to the evidentiary portion of the hearing. And then obviously we have to meet the legal standard, which relates to whether or not the warrant would have issued had that information been included, and that's really a legal argument, not an evidentiary argument.
Which ultimately, under our established case law, and I take it it's both in Massachusetts and in Connecticut, following the Franks line of cases, is that if there was a material omission, then the court should consider whether or not the warrant still establishes probable cause if that omitted information had been available to the magistrate.
That's correct. And obviously we are talking about, as you are here, basically credibility. I mean, that's really the issue here. And that's in stark contrast, for example, the one case cited by the Commonwealth, which is an old case, I think, out of Oregon. There was, the court said there was physical corroboration of what the informant who had failed the polygraph had said, and therefore they said, well, that's enough. Here, there's, as I recall, there's zero corroboration about anything relating to 114 Lake Avenue, other than what came out of Mr. Ortiz's mouth. So our position is, if his credibility is basically worthless, then there's no way a magistrate could properly have issued the warrant.
All right. Now, let's frame the issue a little bit more precisely. Ordinarily, on a motion to suppress a search warrant, the analysis is based on what we call the four corners of the warrant and the warrant materials. A search warrant may issue under the Fourth Amendment only where it is supported by probable cause, and ordinarily probable cause is established through the submission of a sworn affidavit. Any affidavit is by definition sworn. In this case, an affidavit was submitted by detectives from the Bristol, Connecticut Police Department, and it was on the basis of that affidavit that a justice in Connecticut issued this search warrant. There is no mention whatsoever anywhere in the affidavit of a polygraph. So the issue of polygraph is outside of the four corners of the warrant materials. You have now submitted, in support of your motion, what purports to be a police report of the Bristol Police Department indicating that Mr. Ortiz was in fact given a polygraph. A series of questions were put to him, and at least in 3 areas, there was an indication, according to the administering officer, of deception. Now that report, in reference to the polygraph, is documented in the Bristol police report. He is outside of the four corners, but certainly frames the issue and gives you the right to raise the issue before this court. As you indicated, the Commonwealth has challenged some aspect of that, and I want to understand from the Commonwealth what their objection is. Whose argument is? Ms. Anderson?
Thank you, Your Honor.
Ms. Anderson, do you disagree with the contents of the Bristol Police Department report relating to the administration of a polygraph?
No, Your Honor. I would like to point out that the time that's included on that report, the time typed as 1907, 7:07 p.m., and if we look at the search warrant, it was signed at approximately 6:30 p.m. So while the polygraph examination likely took place beforehand, my recollection from the transcript of the interviews that the polygraph examination took place on the 26th, beginning around 11 o'clock in the morning. And then this search warrant was signed. Again, the date and the time are included. That's Exhibit 1, page 11 of that search warrant, and shows the time that it was signed as approximately 6:30 p.m. So certainly, I don't think that by simply attaching this report and the affidavit that we've established a deliberate omission. Certainly, there's no evidence, no representation that these detectives knew about the polygraph examination, such that they could have included it in their search warrant application. I think what also is important to remember is the important information...
Well, just stop for 1 moment, because I don't know the answer to this, and you might help me with it. Does the collective knowledge doctrine apply in the context of a Franks claim?
I don't know the specific answer, but I certainly would be willing to move forward and engage in that analysis of even if they should have included, they had this information.
Well, that's a separate argument.
Right. And I think that's ultimately where we get as a legal issue. I don't think an evidentiary hearing is required for 2 reasons. First, they haven't met their burden to establish substantial preliminary showing, which is required under Franks. There is no substantial showing that these detectives should have known. But if that legal principle does apply, the collective knowledge doctrine should have imparted to these detectives something that they should have written down and included in this application to the magistrate, then an evidentiary hearing is still further not required, because we would just look to see if this information included in this affidavit would still establish probable cause. And that's a legal issue for Your Honor to decide. Certainly, it would still establish probable cause. The important information that was gleaned from Ortiz on June 25th was that he had 2 residences, one at 114 Lake Ave, and the second piece of information was that he and Wallace were there at 114 Lake Ave both before and after the murder of Odin Moy. So that's the evidence, that's the information that was put into the search warrant on June 26th by the Bristol detectives to search this potential suspect's residence for evidence related to the murder of Odin Moy. Again, during that search, the detectives see the forerunner, and I think there's a family member that also makes a statement that that forerunner belongs to Aaron Hernandez. The results of the polygraph do nothing to contradict that evidence, residence and where he was before and after. It's important to note the results of the polygraph are directed at 3 specific questions that's included in the report, and they all have to do with the circumstances related to Odenwood's death. Certainly no surprise that deception may be indicated if a suspect is asked about the facts of a homicide. And so even if those facts were included, I don't think we can say wholesale Ortiz is a liar, therefore he has lied about his address, therefore he's lied about his whereabouts before and after, such that the police and then the magistrate cannot rely on that information to establish probable cause to search that location for evidence related to the crime.
In my judgment, the defendant has made a sufficient threshold showing warrant an evidentiary hearing if it can be of value. Mr. Sultan, are you prepared to call witnesses?
Your Honor, I'm not today. I didn't think I had a right to have witnesses here because it's really, as I understand the procedure, we first have to convince the court that we have a right to have a hearing, and I thought it would be presumptuous of me, so I did not seek to have the witness I would call would presumably be the affiant. That's really the only witness I would call from the Bristol PD, and hopefully...
No, we have 2 affiants. Which one?
Well...
We have Detective Dorman and Detective DeFinnings.
Well, the affiant... Well, it looks like I'm trying to figure out who signed the. I guess you're right. They both signed it. So I guess we would want them both here. Hopefully, the Commonwealth would be able to assist in procuring their attendance, so we wouldn't have to go through the cumbersome and expensive out-of-state subpoena process for law enforcement.
Are they here today?
No, Your Honor.
Are they on standby?
No, Your Honor.
Mr. Sultan, what is it that you intend to elicit from them? Essentially to corroborate the polygraph report?
Your Honor, it would simply be to, and maybe this can be done by stipulation, frankly.
Well, that's what I'm wondering.
If they're prepared to do it, their credibility is not necessarily an issue. Were they aware, when they executed this affidavit and filed it with the court in connection with an application for search warrant, that Carlos Ortiz had failed a polygraph exam? And that's essentially the issue. If they were not aware of it, then I guess the issue would be recklessness is still a standard under Frank, so the question is, do they make any effort to inquire about the results of the polygraph exam? Just to get the chronology straight, Your Honor, if I may, since Ms. Anderson raised it, there were 3 volumes that have now been transcribed of Carlos Ortiz's interview, which started, the first volume started on the afternoon of June 25th. At the end of volume 1, page 202, Sergeant Moran of the Massachusetts State Police says, it's 6:05. And at that point, the interview moved from the probation office where it started on the afternoon of the 25th to the probation office, to the police station. That's what Sergeant Moran says, we're going to the police station. At the beginning of volume 2, presumably shortly after 6:05, Detective Elliott of the State Police says, quote, we came from the probation office over here, okay? And then they read Ortiz's rights again. And at the end of volume 2, page 132, which is now into the evening of the 25th, Sergeant Moran says, quote, page 132, let me get that polygraph guy in here. You pass the test, then we will talk to them, meaning the people that Ortiz was, other law enforcement people that Ortiz wanted some help with. And And then volume 3 is the polygraph. At the beginning of the polygraph, Sergeant Werner, who is administering the polygraph, says...
is this now the next day?
No, well, no, this is not the next day.
This is 25th?
This is still the evening of the 25th, page 5. This is now volume 3 of this ongoing Ortiz encounter. The polygraph administrator says, quote, "It is 11:01," close quote. So our position is that is 11:01 p.m. on the 25th of June 2013, and the polygraph goes into the early morning of the 26th. So it appears pretty clear to us that that's when the polygraph took place. Late night of the 25th, early morning of 26th, certainly well before the application and affidavit were filed during the day on the 26th. So it certainly is a live issue, Your Honor.
You've referenced 3 volumes of transcripts.
Yes, Your Honor.
I don't believe they're before the court.
I think that's correct, Your Honor, and we will supply all 3 because I think the court
Does the
needs...
Commonwealth have them?
We have them not with us today.
But you had volumes 1, 2, and 3.
Yes,
You're
and
familiar with the content and the times.
I am now, and I will stand corrected as to 11 o'clock, it was p.m. Instead of a.m. My reading was a.m. It is p.m. on the 25th.
Now let's talk about who was doing the interviews in volumes 1, 2, and 3. I heard reference to the Massachusetts State Police. They're, of course, conducting the Golden Lloyd homicide, I take it. Are the Bristol, Connecticut police involved? Is there any dispute about that?
No, I think it was only, as I recall, Your Honor, it was just, it was 2 Massachusetts State Police who were conducting the interview, and then they used a polygraph administrator from Bristol, Scott Warner. He's with the Bristol.
When you say
Bristol, he's with the Bristol PD.
Bristol, Connecticut
Yes,
PD.
yes, sir. So he presumes. I mean, if there's not going to be a stipulation and we have to figure out who really told whom, then we might need more witnesses, I suppose, potentially. I'm trying to streamline it if I can.
Ms. Anderson, is there any dispute but that the Bristol detectives that sought this search warrant were at least aware, if not fully involved, in the events of June 25?
I don't know that I have an answer to that question.
Well, I take it someone arranged for the Bristol polygrapher to be available.
Yes,
And who did that?
I do not know the fact of that.
Would you think it likely was a detective with the department?
I would.
It looks like the only affiant is Detective Gary Dorman. She identifies herself as the affiant on the first page of the affidavit. Oh, no, wrong. Mr. Rankin points out that there are 2. You're right.
Co-affiant.
Co-affiant, I'm sorry. I retract that. Right, they're both affiant.
And both of those detectives are certainly involved in the investigation, certainly know about Ortiz's interview on the 25th.
Yeah.
So I guess at what point did they drop off and go write this affidavit as a practical matter? I don't know the answer to that. I think we can jump to the legal issue. The Commonwealth's not willing to concede that they knew about it. The Commonwealth's not willing to concede that they deliberately omitted it. But I think that we can resolve this motion by just getting to that point. I don't think that there's enough legal basis.
Okay, how do we get to the ultimate issue without resolving those predicate factual determinations?
I think we can do it as even assuming that these facts to be true, that there is no probable cause if the magistrate would have been, there is still probable cause if the magistrate had been presented with the information contained within this polygraph report in that search warrant affidavit.
I could make that determination as a matter of legal analysis. But if I were wrong, then what? You don't want to come back here 3 years from now to relitigate the fact determination that we can easily make now.
I do. I suppose it is another basis on which the Commonwealth can prevail. If Your Honor makes a factual finding, first, that these detectives were not aware, or second, that these detectives did not deliberately or recklessly omit any information, that ends the inquiry right there. You don't even go forward.
Let me see counsel at sidebar.
Learned that he did know about the polygraph after it occurred. I believe it was video recorded and they had watched it. Obviously the video recording doesn't give you the results of the polygraph, but I think we can move forward with the basis that the detectives knew about the polygraph and knew about the results before that search warrant was signed.
So those are facts that you would be willing to concede or stipulate to.
Yes.
Mr. Sultan, with regard to your claims, as it relates to omitted information, does that stipulation, or is that sufficient to stipulate for purposes of your claims?
Yes, Your Honor. I think we've just saved ourselves an evidentiary here.
Okay. Then I will accept as a stipulated fact that Detective Dorman was the affiant, and together with a second detective, defendants, for the search warrant affidavit of June 26. That at the time he prepared the affidavit, submitted it for review in connection with the application for search warrant, he had viewed a video of the administration of a polygraph to Mr. Ortiz, and he was aware that deception had been indicated in, I take it, in 3 areas as set forth in the Bristol Police Department report.
Your Honor, I think there's one other piece that we know that I think that we need, that I think the Commonwealth may be willing to stipulate to, and that is that Detective Dorman deliberately failed to include that information in the warrant affidavit.
Yes, Your Honor, and the reason why it's not included is that it is not the practice of the Bristol Police Department or the prosecutors in Connecticut to include either positive or negative polygraph results within their affidavits. And like Massachusetts, the polygraph results are not admissible at a trial or other hearing proceeding.
Mr. Sultan, to the extent that becomes a part of a stipulation, what do you say?
Well, frankly, Your Honor, I don't really care what the reason is. They deliberately omitted it, and they may have some self-serving explanation for why they omitted it, but it was deliberately omitted, and that, I think, for Frank's purposes, is what's important.
Well, can I accept, for purposes of stipulated facts, that Detective Dorman would say it is the policy of the Bristol Police Department not to include any reference to a polygraph, either passing or failing?
I have no problem with that, Your Honor.
The Commonwealth further asserts that Connecticut law, like Massachusetts law, does not admit polygraphs in evidence.
I don't know whether that's, I don't doubt the good faith of the Commonwealth, but that's information apparently that was imparted to them by this detective, and I have no idea as a matter of law whether that is correct or not.
I suppose I could take judicial notice of the laws of another state to the extent they're published laws.
Yes, Your Honor.
Okay. All right. And with regard to the issues before me, of course, I have the search warrant, the affidavit, and the application search warrant. And those are typically the four corners I consider. It seems appropriate, in addition to the stipulation that the parties have entered into, that I also receive as an exhibit for purposes of this motion the Bristol Police Department polygraph report, 3 pages in length. Does either side disagree with that?
No, Your Honor.
No, Your Honor.
All right, so that's the record evidence now before me.
Your Honor, you should have, I think, as well, the volume, that is volume 3 of the Ortiz interview, which is, in fact, a polygraph exam. And
Well, I don't have it.
Well, the parties, I think, should submit that to the court. I think that should be part of the record.
Do you want to submit that now?
We can do that, Your Honor.
Is there any objection to that conduct? Mr. Sultan, as I understand it, the sole basis for your Frank's claim relates to the omission of this polygraph information.
Well, that's correct, Your Honor, and I think it's significant to point out that while this is a Connecticut warrant, this is all done, obviously, pursuant to the request of the Massachusetts State Police. Essentially, whatever is being done in Bristol, they're simply serving as the agents of the Massachusetts State Police for these purposes. It was at the behest of the Massachusetts State Police that Ortiz was basically lured to his probation office on the 25th. The Massachusetts State Police were waiting for him there. They interviewed him for hours. They then turned him over to the Bristol PD polygrapher, and then it was at the behest of Massachusetts, I submit, that this warrant was applied for and obtained. So I think that is material to the court's analysis of this, that yes, it is technically speaking a Connecticut warrant, but it is all being directed, supervised, and controlled, basically, by Massachusetts.
Crime under investigation is a Massachusetts crime.
Correct, Your Honor. Yes.
I don't think there's any dispute as to that fact.
And Your Honor is correct that is the basis for our claim, is that this particular information, which we say goes directly to Ortiz's credibility, was deliberately omitted from the affidavit, and that surely the inclusion of that information could have, and indeed probably would have, affected the magistrate's assessment of the reliability of the information that was being provided in that affidavit. And if you omit the information provided by Ortiz as unreliable, that is paragraphs 9 through 14 of the affidavit, there is no nexus at all to 114 Lake Avenue remaining, and there's not probable cause to issue the warrant. And I guess to me the analogy would be, because I haven't found a case like this in Massachusetts, if this was a challenge kind of under Aguilar-Spinelli, under that line of cases, you had information from a confidential informant, surely if that confidential informant had failed a polygraph on basically the same subject matter as the matter the warrant was being sought for, it is really, and I haven't researched this, so I can't cite the court with a case right now, but it's hard for me to believe that a warrant would be upheld with that kind of information omitted. It is completely immaterial that the results of a polygraph examination are not admissible at a criminal trial. I mean, that's got nothing to do with whether or not Ortiz's flunking this test would be material to a magistrate's assessment of the reliability of the information that was being provided. I mean, why did they give him a polygraph? They gave him a polygraph to see if he was a reliable witness, and he failed that test. And surely a judge or a magistrate evaluating the reliability of this information, that is the credibility of Ortiz, when that is all that's being proffered as to why we should grant a search warrant to search this house, surely that would be material. And surely its deliberate omission taints that warrant, fatally taints that warrant. That's our argument, Your Honor.
Commonwealth.
Your Honor, omission of the polygraph result is immaterial to determination of probable cause. I think it's important to note the questions that were asked in which deception was indicated. Those questions were, did you shoot O? Did you shoot O that day? Do you get out of the car when O was shot? They are very specific questions related to the murder of Owen Lloyd, and I don't know that it's a far stretch, given the investigation, that Ortiz would lie about those answers, that he would say no, and deception would be indicated. That certainly can't defeat a showing of probable cause in which the detectives are allowed and ought to rely on information that he provided the day before, including his address and his whereabouts before and after the murder. I guess even if he was lying about all of those things, that he didn't live there and that he wasn't there before and after the murder, I don't think that we require police to take that at his word and would not be allowed to search those locations for evidence related to the crime. I do cite 2 out-of-jurisdiction cases that are similar factual circumstances where a witness flunking or failing a polygraph was not included in a search warrant affidavit. And in both of those cases, the search warrant affidavit and the search were affirmed. To that end, concluding that because he, quote-unquote, failed a lie detector test, I think that's a misnomer, and that's a layman's interpretation of the result. It doesn't automatically mean everything that comes out of that witness's mouth is a lie, and automatically mean that therefore he is incredible on everything. Again, particularly here on information that probably was otherwise ascertainable. Where Ortiz lived, where he spent his time, as a preliminary matter. And just one further argument that I think the Commonwealth would have added to its motion in opposition, had it seen the affidavit establishing the reasonable expectation of privacy, and that would be an inevitable discovery argument, that even if these Bristol detectives were unlawfully at 114 Lake Avenue, even if they were not supposed to be there and wouldn't have made those observations otherwise, that we have an affidavit from the defendant saying, I always stayed with my cousins at 114 Lake Ave when I visited Bristol. I kept some clothes and other personal possessions there. I don't think that it's unreasonable or a far stretch to think that the Boston police detectives working on this case would have learned that same information and would have obtained the same search warrant searching for the defendant's clothes and other personal possessions at 114 Lake Avenue, like they did at all of the defendant's other residences. So I guess that would be in the alternative, even if this court were to find that probable cause was, there was no probable cause for that search warrant to issue, had the Ortiz polygraph information been included. In that case, it would be inevitable discovery. And the two subsequent search warrants dated June 28th and July 1st for the seizure and then for the search, which in no way reference, in no way rely upon any of the Ortiz information. And I don't hear them being contested today.
Let me just ask you, the polygraph report references 3 areas of deception that have been mentioned during your argument. Did you shoot O? Did you shoot O that day? Do you get out of the car when O was shot? And the witness evidencing deception with regard to his negative answer to each of those questions. Those are the 3 areas, according to the report, where deception was indicated. And now been given volume 3, polygraph test itself. We haven't reviewed it because it just received it. But let me ask to those familiar with it, is this going to indicate areas of non-deception?
It's not my understanding that this is the report as a result of that interview, that deception was indicated in these 3 areas. Arguably,
were these the only 3 questions that were put to Ortiz?
No, Your Honor has a 240-page transcript, so there was an interview. I'm not sure, I haven't watched it personally, so I'm not sure how much of it is polygraph or how much of it is conversation. There does seem to be at the beginning some...
Was there a question about 114 Lake?
I didn't see one.
All right. Anything further?
No, Your Honor. Thank you.
So,
Your Honor, as I hear the court's questions, I think it would be germane for the court to add to include in the record, and we will submit to it later today, volumes 1 and 2 of the Ortiz interview. Because basically, what the court will see is this is somebody who just changed the story over and over and over and over again for hours. In the polygraph, as the court knows, when polygraphs are conducted, they focus on very specific questions that they're actually testing. So those are the only 3 questions, I believe, that were actually...
Now you have controlled questions.
Right.
And then you have the pertinent questions.
Right. So these are the only pertinent questions, I believe, that they were actually testing. But as with a witness at a trial, I mean, if you can show a witness is lying about A, B, and C, that's a pretty good argument that the finder of fact, whoever it is, should not rely on that witness. Of course, Ms. Anderson is right. It doesn't automatically mean he was lying about everything. That's true. But surely it's something that somebody considering the reliability of this man's information would have taken into account and had a right to know, and that's really our
Although I
argument.
see a good deal of what they attribute to Ortiz, then confirmed by some other investigative activity.
Well, not on 114 Lake Avenue.
No, in a number of areas, through surveillance videos that were uncovered or other sources of information. It seems to me, even with knowledge of the failed polygraph, some of what he said was demonstrated to be correct.
And some of what he said, I think, was contradicted.
Perhaps so. All right, if you intend to offer volumes 1 and 2, do that. Otherwise, I have the record basis upon which I'll decide and consider the omitted information. And that motion will be taken under advisement. The next motion before me is the defendant's motion to dismiss the indictment charging Mr. Hernandez with intimidation as it relates to Alexander Bradley. That was an indictment returned in 2015, separate and apart from the indictments alleging the crimes of murder. Mr. Sultan, I have your motion to dismiss, supported by a memoranda, and then supported by a number of exhibits, some under seal as it relates to grand jury testimony and the transcripts of grand jury testimony. I have the Commonwealth's opposition and memorandum in opposition.
I filed a reply memorandum, Your Honor, the day after the Commonwealth filed their memorandum. It was filed on October 2nd.
Okay, I also have that. I've seen that. Do you want to be heard now on this motion?
Yes, Your Honor, thank you. Your Honor, there are 3 grounds why this motion should be dismissed. The first is simply McCarthy grounds, that is insufficient evidence of specific intent. One of the elements, obviously, of witness intimidation is that whatever the defendant allegedly did, he did for the specific purpose of interfering with an investigation or a judicial proceeding. That's one of the elements of the crime. And here, Your Honor, evidence of that required critical nexus is completely lacking. Mr. Bradley first said repeatedly that he didn't know who shot him, and then eventually, when he started cooperating with the Commonwealth, he claimed that Mr. Hernandez did it. However, even then, Mr. Bradley, when he was specifically asked if the reason he was shot was because of the Boston homicide, he said he didn't think there was such a connection. He denied the connection.
And I'm sorry, be a little specific as to which statement that is or the updated testimony.
Let me get my memo. When he was interviewed this is page 3 of our memo, when he was interviewed on October 8th, 2013, this was Grand Jury Exhibit 52, he was asked, is the reason why he shot you about this, meaning the Boston shooting? His answer was, I honestly, if I was going to call it, I would say no, but as time went on, I started wondering. That's the best they have from Bradley. And then Bradley talks about, in the grand jury and in his recorded interview, these 2 heated arguments that he had with Mr. Hernandez the night he was shot, shortly before he was shot. One, he says, was about paying the bill at a nightclub in Florida, and the second one was about his desire to go back to the club where he had apparently left his cell phone to retrieve his phone, and Mr. Hernandez not wanting to turn around and go back to the club to do that. He describes those 2 heated arguments that happened just before he was shot, and then when he's pressed he mentions, oh yeah, we had a conversation, the Commonwealth says it was 3 days earlier in another club in Florida, where Bradley supposedly made a reference to, quote, the stupid shit you did up there in Boston, close quote, and Bradley says that Hernandez gave him an angry look. That's it. That's what they're relying upon for nexus. This conversation that Bradley says happened 3 days earlier, where Bradley mentioned the stupid shit you did up there in Boston, and Hernandez supposedly gives him an angry look. That is not evidence, certainly not establishing probable cause, that if Hernandez shot Bradley, which we certainly don't concede, that he did so in any way, shape, or form to intimidate him as a witness. This is their theory, but this is basically a concocted fantasy. This is not probable cause. And the cases that the Commonwealth cites are all cases where there clearly is such a nexus, where there's a close nexus in time of the act of the defendant to the legal proceeding. I mean, here, this is something that basically, even if you take Bradley at his word, this is something that happens basically out of the blue in February of 2013, some 7 months after the shooting takes place in Boston. Bradley had testified before a Bristol grand jury that everything was fine and dandy down there until the night he got shot. I mean, there's just no basis. There's no proof of any nexus. And that kind of a thin reed is simply insufficient to indict somebody for this kind of a specific intent crime. Basically what they're saying is Bradley was a witness, Bradley was shot, therefore he must have been shot because he was a witness. And they just don't have enough to get over the rail on that, Your Honor. That's the first argument. The second argument, Your Honor, is that by omitting critical evidence about Bradley's credibility before the grand jury presentation was fatally, the integrity of the grand jury proceeding was impaired, basically a Mayfield-Odell ground. And here, Your Honor, Bradley had, it wasn't just that Bradley said in Florida he didn't want to cooperate. That's not what we're talking about, Your Honor. Bradley told 2 police officers, a witness who responded right after he was shot, and his treating physician at the hospital when he was asked, he said he did not know who shot him. And later on, much later on, he's trying to blame it on Aaron Hernandez. The grand jury was never told that he had told 2 police officers, a witness at the scene, and his treating physician that he did not know who had shot him. And therefore, the grand jurors were really, we say, misled. I mean, they were not able to meaningfully assess Bradley's latest story, pointing the finger at Hernandez, because they didn't know what he had said earlier, and they should have been told that. And moreover, Your Honor, with respect to this issue of specific intent, they were not told that Bradley had told a Bristol grand jury, which the Commonwealth well knew when they put him in the Suffolk grand jury, that everything was fine in Florida, they were having a good time before the night he was shot, and he had made no mention whatsoever before the Bristol grand jury of this supposed conversation he came up with 3 nights earlier when he supposedly was given an angry look by Hernandez. No mention of that at all. And again, where their whole case against Hernandez on the Florida shooting, based on their grand jury presentation, rests on Bradley and Bradley's credibility, the deliberate omission of these critical pieces of information, which really undercuts his credibility, impaired the integrity of the proceeding, and really made it impossible for the grand jurors to objectively consider the relevant evidence. The third argument, Your Honor, as to why the motion to dismiss should be allowed is that this court does not have jurisdiction. And the reason the court doesn't have jurisdiction is because all of the alleged acts and all of the alleged elements took place in Florida. And it's essentially an extraterritorial crime. The Commonwealth cites the venue. They cite the statute, which says that this in a case under this for witness intimidation can be brought basically in any county, in the county where the case is pending. That is the underlying case. We say that's a venue statute. Looks like a lot of other venue statutes, which talk about what county you can bring a case in. That venue statute does not confer jurisdiction. There's no evidence it was intended to confer jurisdiction, and it should be read as a venue statute, and venues has nothing to do with jurisdiction. The Commonwealth also argues it falls under the effects doctrine, which is sort of an exception to this rule against extraterritorial jurisdiction, because the underlying case that was being investigated and ultimately was going to be prosecuted was in Massachusetts. And that's a doctrine that there are a few cases in Massachusetts that have explored the reach of that doctrine. There's an appeals court case called Armstrong, which spent several pages really discussing its reach. And Armstrong basically says where all the elements and all the acts are outside of Massachusetts, you can't stretch that doctrine that far. We say that it's Armstrong that applies here. The Commonwealth cites an unpublished summary decision of the appeals.
What about Commonwealth versus Hare? It's the first case the Commonwealth's relying on from 1972, quoting, "If the state succeeds in getting the defendant within its power, the law of this Commonwealth permits prosecution of the defendant for acts done outside its borders, but intended to have an effect within the Commonwealth." The effect here within the Commonwealth, so the Commonwealth claims, is to silence Mr. Bradley with regard to a Boston investigation. Well, why doesn't the language of Hare fully apply here, and Hare ultimately building upon the effects doctrine as formulated by Oliver Wendell Holmes?
Well, Your Honor, I mean the language of Hare certainly is part of the doctrine, but I would say that Hare, which was a 1972 case, has really been clarified, and the meaning of that language has been refined in subsequent cases, including Armstrong, and that's 2008 case, and there are some other, the other case is, that's really, I think Armstrong is really the most recent published exposition of that doctrine, what that actually means. And what Armstrong says is, if you read that language literally, it would really, the exception would essentially swallow the rule, because so many things can happen outside the state that can have an effect inside the state. And Armstrong says that the out-of-state acts standing alone cannot be deemed to have been, they say, we do not read Strassheim as making the effects doctrine so broad as to empower a state to exercise jurisdiction where all acts in furtherance of the crime and all offense elements of the crime are committed wholly outside the borders of the state. So it's really a question of how far you want to stretch it. And we say that in this case, it's simply stretching it too far to apply it to the facts as alleged by the Commonwealth. Those are the three arguments.
Commonwealth.
Mr. Honor, for the record, I would just state that we have submitted with our filing a CD that contains all of the grand jury minutes, but clearly there's certain grand jury exhibits and certain minutes that are most relevant to the issues at hand. First, Your Honor, just relative to the sufficiency argument by counsel, essentially a McCarthy motion, the court is well aware of the long-standing standard that this is the probable cause to sustain an indictment is a decidedly low standard. and that courts have consistently stated as recently as Moran in 2009 that courts will generally not look into or inquire into the competency or sufficiency of the evidence before a grand jury. It's only whereas in McCarthy, where there was actually no evidence of criminality, that a court should dismiss the indictment. So to narrow the issues for Your Honor, clearly counsel, through their filings and oral argument today, has in fact conceded that the Commonwealth presented sufficient evidence that Aaron Hernandez shot Alexander Bradley. The defendant also concedes in his argument that the Commonwealth presented sufficient evidence before the grand jury that Mr. Bradley would qualify as a potential witness to a crime pursuant to Chapter 268, Section 13B. So the only issue before this court is whether or not the Commonwealth has proven that the intent behind this was to impair the integrity of an investigation and to essentially silence Alexander Bradley relative to him being a witness in a crime. So the evidence really relies upon getting into the mind of the defendant. The Commonwealth must prove that the intent was to impede, obstruct an investigation. The investigation being into 2012, July 16, 2012 homicides of Daniel D'Abreu and Sapiro Furtado. So essentially, the Commonwealth is suggesting to the court that you have to take in context the entirety of the evidence presented on this, and in doing so, a reasonable juror could infer that the intention behind Mr. Hernandez's acts was, in fact, to impede, obstruct the investigation into the murders. Now, importantly, as the case law suggests, it does not have to be an inescapable conclusion. The defense seems to argue, well, there's another reason why Mr. Hernandez may have shot Mr. Bradley, and therefore that would make the indictment invalid. Instead, the question for this court is, did we present sufficient evidence to show that the intention was to impede or obstruct Mr. Bradley as a witness to the homicide in 2012? So just taking into context, Your Honor, the evidence presented to the grand jury included that immediately after the homicides, of which, to Mr. Hernandez's knowledge, Mr. Bradley was the only eyewitness. Mr. Hernandez, while in the car ride with Mr. Bradley, stated to him, and this is according to exhibit number 52 before the grand jury, as well as page 40 and 127 of Mr. Bradley's testimony on August 25th, he stated to him, "Don't tell anybody. The only thing I recall him saying to me is I better not say anything. Keep this between us." Following the murder, according to Mr. Bradley, they never ever talked about the homicide again. That's an important point when it comes to asking the jurors and ultimately this court to draw a reasonable inference. According to Mr. Bradley, and this is an exact quote from Mr. Bradley on exhibit 52, a statement he gave, and we didn't even get together too much for a while after that. I don't know, I got the feeling that he was about me, like, he was worried about the fact that I even knew, you know what I mean, and that I was there. So the grand jury heard from Mr. Bradley that the relationship changed, but that it eventually normalized. What's important as well in the context is that Mr. Bradley then describes how increasingly paranoid Mr. Hernandez got in the months that followed as they started to normalize their relationship. In particular, from page 59 of the October 25th grand jury testimony of Mr. Bradley, he states of Mr. Hernandez, he became extremely paranoid about all smartphones, iPhones in particular. I was having a discussion with a female friend. He told me she was probably a cop and don't bring iPhones around him and they could record everything, and he felt like he was being followed in helicopters and all types of things. In that same testimony, Mr. Bradley later stated, if we were somewhere, quote, if we were somewhere and he got stares, and if the guys looked more professional, they had to be police. What's important, Your Honor, is for the grand jury, this is the backdrop that leads you to the point where Mr. Bradley was shot. He was paranoid that the police were investigating him, but Bradley never said anything to him about the incident. The only time that Mr. Bradley said anything to him about the murders from 2012 was exactly the night before Alexander Bradley was shot. And that is on page 72 of the grand jury. I know that there's a cite or a reference to it being 72 hours before the shooting. In fact, it was the very day before Alexander Bradley was shot that he's in a club with Mr. Hernandez. And importantly, again, the context needs to be Bradley had never mentioned the incident at all to Hernandez. While in a club, Mr. Hernandez allegedly sees two individuals who he says were staring at him all night. Mr. Bradley then says to him words to the effect, "That's probably because of the effed up stuff you did in Boston last summer." At that point, the grand jury heard evidence that Mr. Hernandez got visibly upset and gave Mr. Bradley a look. His demeanor changed. It's certainly reasonable for the grand jurors to draw an inference that that upset Mr. Hernandez. It's reasonable to draw an inference that at that point Mr. Hernandez realized that he could no longer trust Mr. Bradley, as at that point in Mr. Hernandez's mind, the only eyewitness to the crime. He could no longer trust him to keep that a secret, and in fact, at that point, formed the intention to kill Alexander Bradley and essentially silence him and the information that he had. Another important fact before the grand jury was that at approximately midnight, according to the grand jury testimony of Sergeant Detective Sullivan, the defendant's iPhone did not hit off of any towers. A grand jury could reasonably infer that the defendant's cell phone was shut off at midnight. The shooting occurs at approximately 5 a.m. Yes, in fact, the defendant, Mr. Bradley, did have an argument about the $10,000 bill at the strip club that Mr. Hernandez apparently wanted Mr. Bradley to split. But that's just one aspect of the case. That's one argument as to why they were having problems. They argued in a car, and Mr. Bradley awoke to the defendant pointing a gun right in his face. He was shot in the head from point-blank range and then pushed out of the car. Based upon all this evidence, the grand jury or any person could reasonably infer that the reason why the defendant shot Mr. Bradley was that he could no longer be trusted, and he was the only eyewitness to the crime. They could also clearly believe that the police were honing in on him and that Bradley could tell them that he was the perpetrator. But there's even more, Your Honor. Exhibit 52 that was referenced by counsel, which is a statement of Mr. Bradley on October 8th before the grand jury 2013, the defense cites the part of Mr. Bradley's statement where he indicates that at first he didn't think the defendant shot him because he was a witness to the murder. And as Mr. Sultan indicated, he ended by saying, as time went on, I started wondering. If you read further in that exhibit, Your Honor, exhibit 52, which I would draw, yeah, I think he even took my phone so I couldn't call for help myself after he shot me. I'm positive that he had to be interested in that phone. So later on in hindsight, I started to figure out that he definitely planned to kill me somehow. Some way, and I think maybe, I know those guys were his friends, but maybe he didn't trust them that much, and they were definitely, then he definitely called this guy Singleton to Florida. Someone told me that Singleton was on his way to Florida. So at some point he devised a plan to kill him. And I'm not sure, but maybe even after the night when I said this, what I said to him about, because of the stupid stuff you did. So essentially, Your Honor, Mr. Bradley himself formed the inference that the reason he was shot was because of the information that he had and the fact that he could no longer be trusted by Mr. Hernandez. The defense argument here, Your Honor, is essentially a trial issue. They're going to say that no, Mr. Bradley was shot because he upset Mr. Hernandez about the bill. The Commonwealth presented more than ample evidence to prove to the jury to make a reasonable inference that he was shot because he was a potential witness to the crime. The Commonwealth cites the Cassiano case, Your Honor, which I think is pretty instructive on this. In that case, a defendant took a photograph of a police officer in the courtroom, in a courthouse lobby, and then later emailed that photograph to his home computer. This is a very similar circumstance where you do not know what his actual intention was, but the grand jurors were reasonable in their assumption or inference that, in fact, that was done to intimidate the police officer. Relative to the Odell issue, Your Honor, briefly on that, as the court is well aware, that's a very high standard. A case can only be dismissed where the prosecutor possesses exculpatory evidence that would greatly undermine the credibility of an important witness or withholds evidence causing a presentation to be so seriously tainted that it impairs the integrity of the grand jury. That's a very high standard. The court is well aware there is no requirement for prosecutors to present all exculpatory evidence to a grand jury. First, relative to defense counsel's argument that the evidence is exclusively on Alexander Bradley's credibility, I would suggest to the court the testimony of Tyrone Crawford does corroborate Mr. Bradley's statement, as well as the testimony of Brooke Wilcox also. First, the defense alleged that the Commonwealth failed to introduce a statement that Mr. Bradley told police officers and others that he didn't know who shot him. The Commonwealth suggests that this was actually presented to the grand jury in that portions of Mr. Bradley's deposition were actually admitted to the grand jury. And in that deposition, Mr. Bradley, in fact, says, in response to questions, that he did tell the police in Palm Beach County that he didn't know who shot him. He does contest the authenticity or whether or not that's accurate. Additionally, what was presented to the grand jury as exhibit number 87 in evidence that was played for the grand jury and is entered as a transcript before this court is an interview of Alexander Bradley the very next day after his shooting on February 14, 2013. In that statement, Mr. Bradley stated, "I have no information for you. You don't want," and then the question was, "You don't want us to investigate or you just don't know?" Mr. Bradley's answer, "I just don't know. There's very little that I know." Mr. Bradley then stated, "I just ain't got no info for you, man, that's all." Later in that statement, he states, they question him, you don't even know where you were the night before? I don't even know where I was. So then he later says, I'm not telling on nobody. The defense is suggesting that the Commonwealth did not present the exculpatory evidence that Mr. Bradley stated at one point that he didn't know who shot him. That very statement that he gave the night after that was presented to the grand jury, in fact, proves that we did present that to the grand jury. Additionally, the transcript from his deposition also indicated that he, in fact, told the police at one point that he didn't know who shot him. The second category that they suggest is an Odell violation, Your Honor, is relative to the grand jury testimony of Mr. Bradley in Bristol. The court should be aware that the Commonwealth was very mindful of not tainting the Suffolk County grand jury, and that the Commonwealth deliberately, as the court reached the grand jury minutes, attempted to not put in information about the Bristol County grand jury investigation. To the extent that Mr. Bradley's testimony before Bristol was not introduced, in that testimony the prosecutor never asked Mr. Bradley anything about the incidents leading up to his shooting in February 13, 2013. In fact, it's clear from exhibit number 52, the interview of Mr. Bradley from October 8, 2013, that in fact it's at that point that Mr. Bradley recognizes the significance of that conversation that he had with Mr. Hernandez the very night before he was shot in the face and pushed out of the car. The Commonwealth also, Your Honor, it should be noted, went through great lengths to introduce what could be considered impeachment evidence of Mr. Bradley. This evidence included the inconsistent recorded statements that Mr. Bradley made in jail, where he told his girlfriend he didn't know anything about the Boston case, the immunity agreement of Mr. Bradley, the fact that he threatened to kill the defendant on multiple occasions if he did not pay money to him, the fact that he filed a lawsuit against Mr. Hernandez, the fact that Mr. Bradley was arrested on a violation of a restraining order, that he was on probation for an OUI, and the fact that he was a marijuana dealer. So the suggestion by defense counsel that the Commonwealth impaired the integrity of the grand jury by not putting what the defense counsel referred to as the warts of Mr. Bradley, or the inconsistencies, has not been shown to the highest standard of Odell. I'd ask the court to look at the case we cited, Commonwealth versus McGahey, on this point, where a prosecutor failed to put before the grand jury the fact that a photographic array, a witness was unable to identify the defendant. That was not found to unfairly impair the integrity of the grand jury. The facts here are much, much less significant. Lastly, Your Honor, I would cite the Nurse case and the Hare case as cited by the court, that this, in fact, is a jurisdiction issue where the Commonwealth has sustained the burden to prove that the intended effects of the defendant's conduct were intended to have the effects within the Commonwealth of Massachusetts. Specifically, the defendant intended not necessarily to only harm Mr. Bradley, but more importantly, intended to affect the integrity of the investigation and to stop the investigation of the Boston homicides. That's essentially the Commonwealth's argument.
You referenced Exhibit 87 before the grand jury, that being an interview of Mr. Bradley was at the day after the shooting.
Yes.
Is that the interview involving a detective, Kenny Smith?
Correct, Your Honor.
And that was submitted as a grand jury exhibit?
Exhibit number 87.
Okay. And what's been given to me is labeled Exhibit A.
It was played for the grand jury, Your Honor. That's noted on the record and clear on the record. Exhibit 87 was played for them in its entirety from beginning to end.
Okay.
The transcript of 87 is Exhibit A.
If I read that correctly, on page 3 of that interview, read it that Mr. Bradley is trying to respect the police officer and what it is they're trying to do, but says what I'm just saying is I ain't telling on nobody. And follow-up question, you don't want to cooperate? Answer, no sir, no sir. That was before the grand jury.
That was before the grand jury, but more importantly, Your Honor, the quote's before that where he says he doesn't know what happened, doesn't even know what club he was at, which again I think is relevant to the defense's contention that we didn't put in evidence that Mr. Bradley initially said he didn't know who shot him. But it was clear in his testimony before the grand jury that he had withheld evidence and had not indicated until he came to the grand jury under an agreement what had happened that night.
Okay, anything further?
No, Your Honor.
Mr. Shelton, any response you want to make?
Just a couple of things, Your Honor. On Hare, which the court asked about, now that I've reread Hare, Hare was a case involving an allegation that the defendant basically procured an abortion for somebody by telling the person where to go in Massachusetts, gave the individual the address of a name of an unlicensed physician in Chelmsford who was going to perform the abortion. So the effect that's being
Where
talked about...
was it that that was done?
Well, it appears that the actual communication, the defendant was in Cleveland. It says as a member of the Cleveland Consultation Service. So the act of informing the woman where to go originated outside of Massachusetts, but what was supposed to take place, namely the abortion, which at the time, back in 1972, was against the law in Massachusetts, that was to take place in Massachusetts. So while the court is correct that the SJC does use the word effect, I would submit in that case, the word effect really refers to act. And that's really what was going on in Hare, because if the court read effect as basically meaning any kind of consequence, then any time anything happened to a potential witness outside of Massachusetts, a Massachusetts court could exercise jurisdiction. And I think, as the court said in Armstrong, that is simply too broad a reading of this doctrine.
No, there has to be some elemental connection.
Yes, sir.
To Massachusetts.
Correct.
Here, that's a homicide, isn't it?
Well, no, Your Honor, because the element, we're talking about the elements of...
criminal investigation.
Well,
or potential criminal investigation is a Massachusetts investigation.
well, that's true, Your Honor, but again...
And that is indeed an element of the statute. You have to do a certain act of conduct with the intent to hinder or obstruct
Right.
a Massachusetts-based, whether actual or prospective or past.
But everything the defendant is supposed to have done occurred outside, including the intent he acted with at the time.
But Armstrong references all elements and predicates occurring outside the Commonwealth. It does seem to me here there is, at least it can be argued elementally, a stronger nexus to the state.
I understand that argument, Your Honor, and I think that's why the court has to look at, as the court did say in Armstrong, you have to look at things like the time, that is, how close in time how connected they are. Because the more diffuse they are in time, the less of a nexus you have. So where the only hook you have is, well, the offense under investigation is a Massachusetts offense, and I understand the court's argument or point that could be arguably enough. At least you should have a close nexus in terms of time. The case the Commonwealth cited was something that happened in a courthouse, in front of it, where there was an actual proceeding. Here we're talking about many months later. There's no indication that Mr. Hernandez is even under investigation at that point for this Boston homicide. It is simply too thin a reed to maintain jurisdiction. That's the argument.
All right. I will take that motion under advisement. I think I have all the submissions to constitute the record evidence that's before me, including the entirety of the grand jury presentation on a CD. Assuming I can figure out how to open the darn thing, then I will have complete access. Just tell me, Mr. Hagan, does the CD contain audio?
It does not. It's transcripts, Your Honor. All in PDF format.
A number of the exhibits were played to the grand jury.
Correct.
Are they part of the record before me, or is it simply reference?
They are both. They are referenced in the grand jury transcripts.
And the transcripts themselves are before me?
Correct.
Okay. Very good. That motion is under advisement. All right, counsel, let me see you all in counsel for our third party in sidebar. All right, counsel, the third motion that is before me is in part a Rule 17 request, which ordinarily is a public proceeding, and the second component of that motion requests the court act on a matter that is ordinarily not open to the public. In this case, it's a little bit different in its procedural background, but nonetheless, what it means is we may have to deal with some of the issues relating to that motion in a closed session. With regard to the Rule 17 aspect of the issue relating to third-party delivery of certain evidence, that motion was filed, I guess, late yesterday afternoon. The defendant has not had a full opportunity to review it or consider it or respond to it, and all parties agree that we should take that up a week from today. So we'll plan on reconvening a week from, today is Tuesday, a week from today, that is Tuesday of next week at 9 a.m.
Your Honor, just for the record, that motion was not filed under seal, but it was filed with a note that I believe that defense counsel would like it to be sealed. The Rule 17 motion, that is. So just want to make sure that's accounted for appropriately at this time.
It'll be sealed until Tuesday, Your Honor, and then the court can decide that.
All right. It will be, and I'll hear you on whether it ought to be under seal beyond next Tuesday. So